All right, I'm Dominic Chaffee. Today I'll be joined by Adam Bagwell. He's our resident IP expert at Aegis Professional Services. And today will be your guide through the first 100 days of your startup. Today we'll be talking about intellectual property, specifically how your startup can protect their intellectual property. In order to do that, we need to know what is intellectual property. Intellectual property is essentially the exclusive right to use a creation of your own intellect. Now, exclusive right, that sounds like a monopoly, right? And usually we think of monopoly as being a bad thing. We have whole bodies of laws that are devoted towards breaking apart monopolies called antitrust law. However, in this case, intellectual property is a good thing. Intellectual property, the exclusive right, incentivizes the creation of new innovative things and inventions through the promise of financial profit. It prevents free riders, and it grows the economy and helps grow our culture as well. So let's see, all right. We have two primary categories of intellectual property. Copyright, which I'll be talking about, and industrial property, which I had never really heard about until today, but what that constitutes is patents, trademarks, trade secrets, and the like, and that's what Adam's going to be talking about. So what is a copyright? Copyright protects an original work of authorship. What is a work? Oh, there's a pretty big list of things that I have here for you, and it's not even an exhausted list. A work consists of, it can be a novel, an ad, it can be choreography, architecture, poems, computer programs, paintings, maps, plays, databases, drawings, reference materials, films, photos, newspapers, music, sculptures, the list can go on. What is not copyright? Ideas are not copyright. Facts, not copyright. And discoveries are not copyright. What is, okay, so it gives you an exclusive right to use or authorize others to use. And how long that lasts for until 50 years after your death. But what is use? What does that allow you to authorize or prohibit other people from doing? Other people are not allowed to reproduce your work. They are not allowed to perform your work in public. They cannot broadcast your work. And they cannot translate or adapt your work if it's too close to the original work. What can they do? That constitutes a doctrine of fair use. Fair use is the use of a work that is okay. Fair use would consist of commentary upon somebody else's work, criticism, parodies, research on somebody else's work, news, teaching, as long as it's cited, as long as you cite the source of the work. Finally, how do we enforce this copyright? We can enforce this through the courts. We can go through we can do civil litigation in order to get monetary damages for any infringement. We can also get an injunction, which is a court order stating that the other person can no longer use that work. And in some rare cases, we can have a criminal prosecution. So how do we protect our copyrights? Actually, copyright is secured automatically upon the creation, upon putting it on a fixed medium. But the question is, who is the author? Usually the author is going to be the person that creates and puts it on that fixed medium. But sometimes we have a doctrine called works for hire. In works for hire, we have an employee who's creating a work for an employer. As long as that employee is working within the scope of his employment and is creating works, the exclusive right to use that work is actually going to belong to the employer, not the employee. Okay, so as I said, this copyright protection happens automatically. But we all know that we can register our copyrights. Well, why would I do that? Well, first of all, it establishes a public record that you have a copyright. So that's going to help people, that's going to put people on notice that they're not allowed to use this work, not allowed to reproduce it. What else does it do? You cannot file suit without actually registering your without registering your copyright. Finally, interestingly enough, it also protects against the importation of infringing works into the United States. One thing everybody probably wants to know is, what is that little C? What is the C with the circle? The C with the circle is a notice of copyright. And what does it have? It includes the little C with the circle, the year of the publication, and the name of the copyright owner. What the main purpose of that is if somebody sees a work that has a notice of copyright on it, and that person infringes that work and later gets sued, they can no longer use the defense of innocent infringement. So that can help the person suing the infringer get more monetary damages in that case. So how do we register for a trademark? It's really very easy. First, go to the easiest way to do it is www.copyright.gov. You submit a filing fee and do the filing form, and submit a copy of the work to be registered, and 3 to 5 months later you have a registered copyright. And at this point I'm going to turn it over for industrial trademarks, or trademarks and patents.
It's a word, symbol, or phrase used to identify a seller's product or services and distinguish them from the products of others. So in order to have a trademark and file the trademark, it has to be distinctive, which means it has to identify the source of the goods. And as you can see, there are 4 levels that a trademark goes through, that from top to bottom, the easiest to trademark to you're going to have a severe problem trying to trademark. You have arbitrary and fanciful. That's like Amazon. When you hear Amazon, you don't automatically think bookseller, as they originally were, or a seller of everything now. It's arbitrary, and because of that, and it's not just descriptive, they are able to get a trademark for that. Suggestive would be something like Coppertone. Coppertone suggests sunscreen, but it doesn't tell you it's sunscreen, so it's more on the arbitrary side, that you have to make some sort of inference to get to this is what the product is. Then the descriptive mark. Descriptive marks are a lot harder to trademark. An example I like to have, I just didn't have the picture for today, is a red wagon. If your company produces red wagons, you're going to have a hard time getting the trademark red wagon on the side of that red wagon, because all it does is merely describe the product or the service. And you can get it, like UPS, if they wanted to get a trademark for brown, they might be able to do that because it's acquired what's called a secondary meaning, where if you go to the average consumer and you say, with regards to shipping, brown, and they'll tell you UPS. That is a secondary meaning, but you have to have been using that for quite some time. So if you're a startup, everything below suggestive is just a bad way to go, because you have to use it for a long time. When you get to generic, you're just not even going to have protection. So if it's just computers, and you sell computers, you're not going to get the trademark, and you've spent a lot of time and money on a trademark or attempting to get a trademark that's not going to get you anywhere. So if you have something that's trademarkable, those rights are acquired in 2 ways. One is just using them in commerce. So most startups, they will start using a particular mark. They have a logo that they like on their website, and they'll start using it. And what you acquire then is called a common law trademark. And that is good in a certain geographic area. So if you're doing it on a website, geographic area is probably going to be most all of Earth. But if you have more of a brick and mortar store and you ship to 3 states, 5 states, you get what's called a common law trademark in those areas. And the other way to do it is you actually file a trademark application with a state or a federal government agency. The state of Missouri has one, and then there's the United States Patent and Trademark Office. Most states, they don't even really review them. They just say, thank you for filing it. We'll take your money. You have your state trademark. And so long as it doesn't conflict directly with somebody else's, you can get a trademark in this state. The best to get, though, is the federal one, because that one that protects you through all the United States. Once it registers, you can then actually go to like the International Trade Commission, other regulatory bodies, and stop things from coming into the country that have that mark on it. So the federal is definitely the way to go if you're a startup that has a website and you really want that national presence. If you're really just going to stay in Missouri, then you maybe consider something a little further down the scale, to maybe just a state law trademark. Okay. So to recap on the trademarks, I thought there was one more slide, but the trademark really is what it defines as who. So if you put it on a product, it's going to tell whoever's buying that product or that service who is providing that in the market. And it really just associates back to your brand. And as a startup, you really want to try to protect that as much as possible because sometimes in the beginning, that's all you have is your name and your goodwill. And that's basically a quick synopsis of trademarks. Now patents, government authorized monopoly essentially. That gives people a period of, well, depending on when the patent issued, anywhere from 17 to 20 years protection. That allows you the exclusive use of whatever your patent invention is. And exclusive use means that you can license it, you can use it yourself, or you could do nothing but stop other people from using your patent. You don't ever have to use it. You can just patent it and say, I don't want anybody else to do it. I don't know exactly why you would want to do that, but that is an option that you have with the patent. And patent rights are often a business's most important IP or intellectual property asset. Since you can patent business methods, which is processes that can happen behind the scenes on a website, a server, as well as the hardware, those new processes, those often form the entire basis of what your intellectual property is. And without that, your business doesn't go very far. So patents are often the best way to pursue that. I know we discussed copyrights a minute ago, and they said you can protect your computer software. Well, copyrights only protect somebody from coming in and copying your code exactly and calling it their own. So like if you copied a disk from Microsoft for Windows, that stops that. But copyright doesn't stop somebody from going and implementing all the methods that underlie Windows on their own. It's patents that stop people from doing that portion of it. So what is patentable? And so I gave you some fun statutory language right from the US government. That's any process, machine, manufacture, or composition of matter, or improvement thereof. So what it comes down to is what can't you patent? You can't patent abstract ideas, laws of nature. Like you can't try to come up with clever language to patent gravity because it's not something you invented or discovered. And no physical phenomenon, which if you follow any of the patent news with respect to like gene sequencing and testing genes, there's been a lot of fights going on regarding is that physical phenomenon just the mere location and the identity of a particular gene. And so there's been a lot of back and forth fighting that has accompanied that. Okay. So then the other requirements for patentability, I gave you the 4 legal terms that if you talk to an attorney, they're gonna spit these words back at you, which is utility, novelty, non-obviousness, and enablement. So I try to kind of put that in some real world terms for people that don't talk like that. Invention has to be useful. I sometimes show a picture of a drill that has a fork on the end and some noodles wrapped around the end. And somebody tried to claim that as an invention because it would just, it's a quick way of loading it onto the fork. And that was determined to not be useful. I mean, it's just, anybody really could do that, and what's the point? It must be new compared to what's called prior art, which can be other patent applications, patents, newspaper articles, anything you can find on the web, something somebody talked about in a bar. I mean, if you can prove it, it has to be new compared to any particular, like one object you can look at. And then the subject as a whole has to be non-obvious to one skilled in the art. So then that's a fancy way of saying that if you're doing a computer program, if another computer programmer could look at it and say, I'm going to take these 5 programs, combine them all together, and I've come to your invention, then it's not really your invention, it's just something that would have been obvious to somebody who does what you do. And the important difference between copyrights and trademarks is that there are no exclusive rights to inventions absent an issued patent. When you affix something in writing, you automatically get the common law copyright. You can then protect it by filing it. Trademarks, you can use something and you get a common law trademark from using it, and then you can later file on it. Patents have no such protection. Without filing an application, going through the process of getting your patent, you have no rights absent that issued patent. So I'm doing everything kind of a high level. If we have questions at the end, you can ask me whatever you'd like. So the most frequent question I get then is, can I file this patent application myself? So I'm a startup, I'm a solo inventor, I don't have a lot of money. And the short answer is, well, yes, you can. I mean, nothing in the law stops you. You're the inventor, you can go and file everything that you want. The slightly less short answer is that you can file it on your own, but patent law is a very specialized area with odd nuances and things that you should and shouldn't say at various points. And if you do say them, they limit what protection you may have down the road. And so you'd likely benefit by at least speaking to an attorney to find out what the best way to go forward is. Because there are ways to write it that I've had some clients that have kind of gone back and forth with, because when I draft the claims of a patent, because the claims really define what your invention is, I try to keep it very broad. Because you go through a process with the patent office where they say, no, you can't patent that, and then you respond with either amending your claims or saying that, yes, I can, and here's why. But if you start with these claims very narrow, you may end up with something that doesn't even cover your own invention. So at the very beginning, you try to keep them very broad so that you have room to work during the process. But if you're not used to doing that on a daily basis, like I've done, the tendency is I want to describe exactly what I'm working on right in front of me, and that may then limit your rights in the future, that by the end of your application process, because patents can take, on average, I just saw a new post, 2 to 3, I think 3 years was the pendency length, the average pendency for an application. So at the end of the 3 years, you want to have something that still covers what your invention is, and doing it right at the beginning is very important so that you have that room. So that is trademarks and patents from a very high level. So I didn't want to get neck deep in all the different doctrines and rules that go into it, but just to kind of give you an idea of why various areas are important. So if there's any questions for Dominic or myself.